was made by the co-investigating judges. The co-investigating judges had fulfilled the conditions for detention in compliance with Rule 63.3a in its fullness and strictness, and there is no infringement or failure in performing their duties. The co-investigating judges based their decision on the existing facts and other evidence in the case filed for the extension of the provisional detention. The co-investigating judges relied on the existing facts and evidence in the case filed, which led them to believe that there is a well-founded reasons to believe that the charged person Ieng Sary may have committed the crimes during the period of Democratic Cambodia from 17 April 75 to 6 January 79. The extension of the provisional detention for the charged person Ieng Sary is a necessary measure in order to 1. Prevent the charged person from exerting pressure on any witness or victim, or prevent any collusion between the charged person and accomplices for the crimes committed under the jurisdiction of the extraordinary chambers. 2. Preserve evidence or prevent its distraction. 3. Ensure the presence of the charged person during the proceedings. 4. Protect the security of the charged person. And 5. Preserve public order. The 5 grounds for detention order for detention under Rule 63.3b are disjunctive. There is no requirement that the co-investigating judges find that every ground is satisfied before they consider that provisional detention is a necessary measure or that its extension is warranted. On the contrary, should they consider that any one of the 5 grounds exists, the test for detention is met. We submit that the case file today contains evidence capable of satisfying an objective observer at this stage of investigation that the appellant may have committed the crimes for which he is currently under investigation. Additionally, 3 of the 5 disjunctive conditions under Rule 63.3b are still fulfilled, thereby rendering provisional detention a necessary measure. Specifically, the charged person's provisional detention is necessary: 1. To ensure his presence during the proceedings; 2. To protect his security; and or 3. To preserve public order. In supporting the above view, I would like to submit to the pre-trial chamber the reasons for extending the provisional detention of the charged person Ieng Sary as follows. The gravity of the crimes charged, the complexity of the case and the extent of the ongoing investigations being carried out by the co-investigating judges. The charged person is faced with several charges in relation to the mode of liability of the joint criminal enterprise, of its extended and systematic character, and such provisional detention is warranted under the internal rules. Regarding the review on the assessment of the reasonable nature of a provisional detention, the ICTY has taken into consideration the length of provisional detention, which is much longer than the reasonable length of time, in light of the gravity of the crimes committed. In order to prevent the charged person from exerting pressures on any witness or victim, the co-investigating judges acknowledged the risk that if the charged person Ieng Sary were to be released on bail, he would definitely attempt or intend to exert pressures on witnesses or victims. The co-investigating judge's acknowledgement is appropriate in light of the evidence in the case file which supports this view. Moreover, Ieng Sary's senior position during the Democratic Cambodia period, during the exiles, and during subsequent Khmer Rouge moments, as well as during the recent political movements, have shown that Ieng Sary is a man of power for the most part of his adulthood. Even today, he still enjoys his popular support from the residents of violent area and those areas. Everyone is aware that the charged person Ieng Sary and his family have great influence spreading over the areas of Thailand and Malay and also in Long Veng. And a number of his relatives are still residing in those locations. Some potential witnesses and victims are also residing in those locations. There are peers and environmental fears spreading around to prevent the witnesses' participation before the extraordinary chambers for fear of revenge and or intimidation. Moreover, it should be noted that there has been no plan to protect those witnesses in the context of general situation in Cambodia, and there have been numerous violent incidents and ammunition explosives are still scattered around throughout Cambodia. Therefore, to ensure the investigations by the co-investigating judges, it is imperative to prevent any pressures being exerted on any witness or victim. Moreover, Ieng Sary has access to the entire case file, including written records of witnesses' statements and complaints. Hence, if the pre-trial chamber decides to release Ieng Sary on bail, it will cause witnesses and victims being fearful. To prevent such risk, it is necessary to extend the provisional detention of the charged person Ieng Sary. During the investigation phase, it is crucial to preserve evidence or to prevent its distraction. This includes the testimonies of witnesses who know about the events they saw or heard. Were the charged person released on bail, these witnesses would be fearful of his presence and dare not participate in the court proceedings. Omission of such participation is a great loss of important evidence. Thus, any possible interference on any witness, as mentioned above, means taking away evidence from the tribunal being in progress. Based on this reason, the extension of provisional detention of the charged person Ieng Sary is a necessary measure. On 17 October 2008, the pre-trial chamber issued a reasoned decision upholding the necessity of his pre-trial detention. This announcement has been made after evidence in the case file has been reviewed at that time. The co-prosecutors submit that the rationale outlined in the detention appeal decision is still valid up to this date and should be upheld. And how arrest, as sought in the appeal, is neither a viable alternative to detention at the ECCC detention facility, nor will it protect the objectives of Rule 63(3)(b). The co-prosecutors therefore request the pre-trial chamber to hold that conditions of detention under Rule 63(3)(b) 3 to 5 are and continue to be satisfied, thereby justifying an extension of the appellant's detention. At this stage, the charged person Ieng Sary is well aware that his alleged offences are severe crimes, internationally condemned, and if convicted, he could face a life. This is the risk he may be willing to take if he were to be released on bail. Moreover, even if the charged person were to be placed under house arrest, this would not satisfactorily mitigate risk through his personal safety. It would be difficult to ensure his safety during transportation from his house to the ECCC hearings. Based on this reason, it is necessary to continue the charged person Ieng Sary's detention to ensure his presence during the court proceedings. At this juncture, everyone is well aware that the charged person Ieng Sary's provisional detention at the ECCC detention facility has been extended by the co-investigating judges. Information on the extension of provisional detention has been known publicly and has been well received and supported by the public, the victims, as well as their families. Specifically, since the commencement of preliminary investigation, the co-prosecutors have received huge numbers of complaints in excess of 3,000 or almost 4,000. This is clearly a testimony indicating that both victims and their families still remember and can never forget the suffering they received during the period the Democratic Cambodia in power, at which time Ieng Sary was the Deputy Prime Minister and member of the Central Standing Committee of the Communist Party of Cambodia. If at this juncture the pre-trial chamber decides to release this charged person on bail, security risk on the charged person can occur due to the feelings of anger and revenge by the public, the victims, and their families. And these feelings arise from their dissatisfaction with the event, and this will place the charged person in an insecure situation. Therefore, in order to ensure the safety of the charged person, it is necessary to continue his provisional detention. Although the crimes have been committed 30 years ago, the victims and their families still remember and cannot forget what happened to them, and they still hold anger inside their hearts in respect of the serious nature of the fact which occurred during that period. Having a glimpse at the current social situation in Cambodia, one can say it still has its fragile characteristic, and this requires thorough consideration. If at this juncture the pre-trial chamber decides to release the charged person on bail, it can cause dissatisfaction from the public, the victims, and their families, and this can lead to public and social disorder. Therefore, it is necessary to continue provisional detention of the charged person Ieng Sary. To honors of the pre-trial chamber, before this chamber, the co-lawyers of the charged person only make submission regarding the issue of their client's health condition and seniority and request the pre-trial chamber to release their client on bail based on these conditions. I would like just to say that they repeat the same thing about the health condition and the old age of their client, as mentioned by my colleague. This means even his lawyers clearly believed their client indeed committed crimes.
outside the co-investigative judge's finding when he indicated that my client was a risk to witnesses and was going to be tampering with evidence. I didn't object to that. I was going to raise it at some point because he went way outside. And that is unacceptable. But at this point, I think this is way beyond the pale. And I will not sit here and allow the prosecutor to make these sorts of arguments at this setting. This is not the purpose for it.
I would like to continue. And I believe that the extension of provincial detention is a necessary measure if they seek the modification of detention from the ECCC detention facility to house arrest. The procedures of the extraordinary chamber do not clearly specify the standard by which release on bail can be granted on health ground. The law on the establishment of the extraordinary chambers states that conditions for the arrest and the custody of the accused shall conform to existing law in force. Article 33 new of the ECCC law. The existing laws encompass the ECCC internal rules and the Code of Criminal Procedure of the Kingdom of Cambodia. The internal rules of the extraordinary chamber indicate that an accused may be released when conditions for detention are no longer met and none of the conditions relates to health issue. Rule 64.1 of the ECCC internal rules. The internal rules also stipulate that the court may order for medical or psychological evaluation to determine whether the accused is physically and mentally fit to stand trial or for any other reasons. These are the internal rules which stipulate based on the Article 32 of the internal rules. The Code of Criminal Procedure of the Kingdom of Cambodia mentions health issue as well. I just want to show the differences between the Code of the Criminal Procedure of the Kingdom of Cambodia about the stages of the pre-trial, and the presiding judge may order a health examination on the accused to determine whether the accused is fit for the arrest. It is in Article 309 of the Code of Criminal Procedure of the Kingdom of Cambodia. Due to the gap in the rules of procedure of the extraordinary chambers, it is necessary to seek guidance in the procedural standards established at international level. Article 12 of the agreement between the Royal Government. Therefore, the co-prosecutors submit that house arrest is unnecessary as the conditions in the detention facility remain appropriately suitable for his detention. In contrast, house arrest cannot provide any better facilitating means than the ECCC detention facility. The ECCC detention facility has been established to conform to the standard and equipped with tools and equipments to provide service to the charged person. Moreover, this detention facility attracts media attention, and during the process of its construction, consultation was made with the Red Cross Committee on the appropriate overview and sketch of the building. As we all know, this detention facility has 5 doctors and 4 nurses for 24-hour medical care with an ambulance on standby. Therefore, the release on bail could only be granted on humanitarian grounds. That is, in a case where a medical expert certifies a charged person has a terminal serious health condition which cannot be treated, and that person will live for only 2 or 3 more months and that Your Honor, as in the condition of the German case, when the two Germans joins together, the General Carriger was arrested and placed in detention. There was an objection to this former General Secretary of the Communist Party of Germany, of the East Germany, and then a medical expert confirmed he would die in 3 months. After the confirmation from an expert like that in such a case, the federal court allowed him to release on bail and to live with his family in Chile. 3 months later, Mr. Rick Henniger passed away. So the conditions in the case filed of the charged person, we cannot accept that request for released on bail and through the house arrest. Also, the co-defense lawyers cannot prove that Ieng Sary's life is at his final stage and that it may cause his death suddenly due to his health, as I have raised earlier regarding the Secretary General of the East German Communist Party, Erich Hooker. The prosecution also submits that if the charged person is under house arrest or even at the hospital, there are no material because it is not appropriate that he has to appear and to be transported to appear before the chambers at the ECCC. In conclusion, in the name of the prosecution of the extraordinary chambers in the courts of Cambodia, I request and submit respectfully to the pre-trial chamber to uphold the extension order for provisional detention dated 10 November 2008 by the co-investigating judges. Thank you. The President, the international co-prosecutor, how long do you need to make your oral submission?
Your Honor, upwards of 15 minutes and less than 30 minutes. Your Honors may be minded to take a break at this stage and then I could resume immediately after lunch, but I'm subject to Your Honor's discretion.
The President, the international co-prosecutor can make your oral submission.
May it please Your Honors. Your Honors are sitting today in this oral hearing to determine a detention, extension and appeal. And I stress detention, extension, appeal. This is not an appeal of detention from the first time when my learned friend's client was arrested in November 2007. That matter, that original detention, was decided by this chamber on the 17th of October 2008. On the 10th of November 2008, what the investigating judges did was that they ruled that there was no material change in circumstance between the 17th of October 2008 and the 10th of November 2008 for them to reconsider conditions of detention, and essentially relying on Your Honour's assessment of the conditions of detention in Your Honour's order of 17th of October 2008, they continued the detention of this charged person for another period of 1 year. Therefore, what was before the investigating judges was Your Honour's very recent assessment and objections of my learned friend of the 28th of October 2008. And on the basis of those two documents, the investigating judges extended the detention. Therefore, the questions that arise in this appeal are very narrow and focused. Whether the investigating judges rightly extended the detention on 10th of November on the basis of the fact that there were no material change in circumstances since the 17th of October 2008, when you had already determined that well-founded reasons existed for any reasonable observer to believe that this charged person may have committed the crimes for which he is being charged, which is 63(3)(a) condition, and also that the last three limbs of 63(3)(b) remained satisfied for him to be continued in detention. My learned friend had raised the issue of health as a corollary matter in this appeal. I shall not refer to that matter because Your Honour has very recently determined that the issue of health did not arise directly and specifically in this appeal. Therefore, I shall skip that matter. I shall essentially address Your Honours then on the question of whether material change of circumstances existed on the 10th of November when the investigating judges decided on their detention extension order, and whose onus was it to bring those material change of circumstances to the attention of the investigating judges, and if material change of circumstances did not exist, then clearly, as the co-prosecutors argue, the investigating judges were right in extending the detention of this charged person. Now I'll refer to the question of material change of circumstances. The appellant, in his objections of the 28th of October 2008, failed to identify any material change of circumstances that would have necessitated the investigating judges to change their opinion from the opinion of Your Honours of the 17th of October. The appellant failed to do that in his objections before the investigating judges on the 28th of October, and indeed he failed to do so in this appeal, which was filed on the 10th of December. Your Honours, as I submitted, found in that order of the 17th of October that both 63(3)(a) conditions were satisfied and 63(3)(b), last three limbs were satisfied. And we submit that those conditions existed on the 17th of October, they existed on the 10th of November when detention was existed, and indeed they exist today for Your Honours to conclude that detention should be continued, and the investigating judges rightly did so on the 10th of November. We also shall submit, and this is a summary of my arguments, my learned friends very elaborately argued these matters, that as he submitted, the detention facility of this institution remains appropriately equipped to handle any medical emergencies, as it has done so in the past 15 or so months of this charged person's detention. We also submit, as argued by my learned friend Mr. Carnavas, that due diligence, although is important in investigation, doesn't arise in the determination of provisional detention under 63(a) or 63(3)(a) or 63(3)(b). There is no legal provision or legal hurdle that a party has to cross in respect of due diligence under 63(3)(a), 63(3)(b). Due diligence may be relevant, but it may be a different forum before which my learned friend has to agitate the due diligence or lack thereof in the investigation of the co-investigating judges. We shall also submit that there was no unreasonable delay in the proceedings against my learned friend's client. This period of 15 months which has taken for the investigation of the case against him, in our most respectful submission, is not unreasonable. It is much lesser than the periods in which accused in other tribunals of similar nature, ICTY, ICTR, have been kept in detention. And indeed, ICTR has not found any period, including a period of 8 years in respect of a particular accused, unreasonable for detention. And we shall also submit that the ECCC, the European Court of Human Rights jurisprudence that my learned friend has cited in his appeal, should be treated with caution by this Honourable Court. That jurisprudence is important. It comes from a very advanced regional jurisdiction towards which this Court has looked for international standards, but the ECCC deals with very focused set of cases. It deals essentially with municipal crimes and crimes committed within the municipal jurisdiction of an ordinary court. I would call them ordinary crimes, while this court deals with extraordinary crimes that shake the conscience of national and international communities. These are clearly, as the investigating judges have held, very complex cases which are different from ordinary cases before national jurisdictions. And most importantly, they deal with investigative bodies which are properly established with all the facilities, forensic and otherwise, at their disposal, while this court deals with an institution that's been very recently established with all the limitations that there are in respect of time and funding. So we would submit that while deciding the period of detention of this charged person, you must consider the question of unreasonable delay with an amount of caution when you consider that in the light of the decisions of the ECCC and other decisions of other parallel international tribunals. Your Honours, my learned friend has adverted to issues of 63.3a and 63.3b conditions, and I shall not dwell upon them because they've already been argued. Suffice it to mention that Your Honours found on the 17th of October that well-founded reasons existed, and I may draw your attention to paragraph 94 of your order of 17th of October, that well-founded reasons existed to continue to hold that this person may have committed crimes within the jurisdiction of this court for which he is being charged in the introductory submission. Indeed, he is being charged for crimes of S21, the detention center in the center of Phnom Penh, for which one of his co-accused, co-charged person, Doik, has recently been indicted and facing trial. So at least one set of crime scene on which this person is being charged has resulted in an indictment before this Honourable Court, and therefore conditions of well-founded reason remain to be satisfied. We also submit that while the investigating judges had added material till the 17th of October 2008 to satisfy Your Honours that well-founded reasons existed on that day, they have continued to add material on the case file to continue to hold that well-founded reasons exist for this person to be detained. And I can just draw your attention to the fact that as of today, there are about 250 statements in the case file, and the figures could be larger than that. Doik, the allegations against Doik in the case file against him have been transferred onto this case file on the 30th of May 2008. There have been upwards of 38 rogatory letters issued by co-investigating judges since July 2008, and indeed after the matter was decided by you in October 2008. 56 rogatory reports have been kept on the case file after Your Honours decided that matter. We, the co-prosecutors, filed the case file with about 123 binders in July of 2007, and the case file has increased both in volume and gravity to the extent that there are about 450 binders on this case file. And I don't want to dwell on the numbers, they're on record before Your Honours, but just to give you some statistics about the investigation conducted by the investigating judges. Of course, it's a matter for trial, and it's a matter for an indicting court to determine whether those statements are of any relevance to my learned friend's client's case. But that stage we shall cross when we come to the stage of indictment. But at this stage, in our respectful submission, due diligence has been exercised by the office of the investigating judges to the extent that evidence has been added. And I may bring it to your Honor's attention the fact that there may not be all evidence that may directly name this charged person. There may not be all evidence in which his personal conduct may have been identified. Because ultimately, in cases of this magnitude and this size and this complexity, there has to be, in our most respectful submission, a crime-based evidence that crimes occurred. Those crimes may not necessarily be physically perpetrated by my learned friend's clients, but at least crimes were committed by certain people whom, in our respectful submissions, my learned friend's client was either directing as a superior, or he was part and parcel of a joint criminal enterprise with those physical perpetrators, and which we shall submit before the investigating judges, make him equally culpable as a co-perpetrator for the crimes committed by the physical perpetrators. The second set of evidence that's been brought by the investigating judges...
If I may, Your Honor, now we're going into the facts of the case. And if we're going to be relieved of our confidentiality duties to go at this moment, then fine. But I certainly didn't come here to plead what is in the investigative file. We've argued due diligence, but now I think my friend is going well beyond that point. And I did give him some latitude, but I believe he needs to move on. Otherwise, we risk going into confidential matters, because now he's directly discussing evidence which he believes, and he's giving testimony, in effect, as an advocate, he's giving testimony as to what he believes the evidence shows or